Hello. We're going to go ahead and get started. Welcome to the New America Foundation. My name is Andres Martinez. I direct the Schwartz Fellows program here, and thank you all for being here. This event is being webcast live, so please bear that in mind. If you want to say something really provocative at the end, it's going to be captured beyond this building. I wanted to introduce our speakers tonight. We're very fortunate to have the two of these great thinkers on stage. I'm a big fan of both of them. Jeff Shesol's book, Supreme Power, has been reviewed wide and far, and it's gotten tremendous reviews. And I think the New York Times said it was deeply researched and beautifully written, which is quite an accolade that all writers aspire to. And our subject couldn't be timelier tonight. Jeff's first book was Mutual Contempt, which was a look at the fraught relationship between Robert Kennedy and Lyndon Johnson. And I've heard the story that President Clinton, when the book came out in the 90s, was such a fan of the book that he invited Jeff in to talk about it. And apparently at the end of this discussion offered Jeff a speechwriting gig on the spot. So maybe if President Obama likes Supreme Power that much, you might get a Supreme Court gig out of it, because there's an opening there, which maybe we can get into as well. And I actually think that title of Mutual Contempt would be perhaps an appropriate title for if somebody did an overview history of the relationship between the executive and judicial branches. But congratulations on your book, and thanks for coming. Walter Dellinger, as most of you probably know, is one of the real stars of Washington's legal community and our nation's legal community. He's been the assistant attorney general. He has been the solicitor general. He's argued before the court numerous times. He's one of the leading constitutional scholars in the country, having taught at Duke. He's a visiting professor at Harvard Law School. He now heads up the appellate practice at O'Melveny and Myers in town. And I met Walter a couple of times at there's an annual Supreme Court preview that the law school at William and Mary puts on. And Walter was a participant, and a few years back when I was writing editorials, I went out there, and I was quite struck not only by Walter's brilliance, but by his great storytelling ability and his sort of provocative nature of his take on things. And so I thought this event doesn't really need a moderator. So Walter has agreed to be the provocateur and engage Jeff on his book and also share his insights. So I can just sort of enjoy the conversation and let Walter do the moderating too. So without further ado, Walter, it's all yours.
Jeff, I agree with everything good that everybody said about the book. It's a page turner. It's gripping. It's timely. It's topical. It is not only beautifully written and deeply researched. It's deeply written and beautifully researched. So it's great. Now, in 1932. Franklin Roosevelt is campaigning in the midst of this devastating depression, a depression that has crushed the sort of three pillars of faith of America: faith in the Republican Party, faith in corporate America, faith in private charity. All of that has been crushed under the weight of this extraordinary depression. Even then, even before he's elected, there's signs that he saw the court as a potential problem. Tell me about that.
Sure. Well, first I want to thank you for joining me up here. It's an honor for me to be up here as a non-lawyer, particularly. I should say that first as a disclaimer, to be up here with a thinker and a practitioner of your caliber. So thank you, and thank you, Andreas and New America, for having us both up here. Absolutely, the premise of your question is absolutely right. Roosevelt did see this coming. Most observers saw it coming, actually. The Supreme Court, by 1932, when Roosevelt was first running for president, had been a powerfully conservative force in American life for over a half a century. In fact, it had almost always been conservative. There really wasn't a great liberal Supreme Court that anyone could point to. There had been liberal justices, and there were certainly some on the court at that time. But Roosevelt knew that his plans for the nation were going to run headlong into this court. And during the 1932 campaign, he actually brought this up once, only once, at a campaign stop in Baltimore in the last couple of weeks of the campaign. And he said, and it seems to have been an ad-lib line, he said, the Republican Party has been in control of all three branches of government. It's in control of the White House, it's in control of the Congress, and for good measure, it's in control of the Supreme Court as well. Well, there was a little explosion that went off when he said that, and the Republicans who had been waiting for Roosevelt to screw up thought, this is it. He's finally gone too far. And there were editorials charging Roosevelt with politicizing the court, and of course we all know the court isn't political. I mean, yes, some of these gentlemen had served at one point as senators and other elected offices, and they're all political appointees, but you know, old gentlemen might sit around and play cards and talk about politics in the way, the New York Times said, in the way they talk about the pennant race, from some degree of remove. Isn't it interesting that they had no stake in the game anymore? And this idea, and I'm not telling you anything you don't know, but this idea had been under assault in the law schools for some time.
That's right. It was shocking when Roosevelt, in that Baltimore speech, when Roosevelt lists the Supreme Court as in the control of the Republican Party, it flew in the face of the ideology of what you might call the judge as umpire, the disinterested, non-political elite, so that the idea that whatever one's party affiliation you might have had before donning the robe, that of course no political party ever controlled the court. So it was seen in that sense as very, in those circles which were adhering to this older and perhaps newer notion, as a shocking manifestation. But you're right, there was a new wind blowing in the law schools from around when the turn of the century, I guess, right?
Really, I mean, it was really Holmes in a way that kicked it off in the late 19th century, but it really had gained a lot of momentum in the law schools in the 1920s, and referring, of course, to the legal realist movement. And Holmes and others had argued that judges are actually sitting and doing something with their day. They're actually making decisions. And the prevailing notion on the right had been that judges actually don't exercise much judgment at all. They're experts in the science of the law, and that they apply certain legal formulas, and they would take, and this is the language of the conservatives themselves, that they would take the article in the Constitution that had been challenged, they would take the statute that was in question, and they would simply line them up and see if they matched up. And if they didn't, then it was unconstitutional, and if they did, then it was fine. And Roscoe Pound at Harvard called this the slot machine theory of jurisprudence. And Holmes and others were working very hard to explode this idea, and certainly Roosevelt didn't buy it at all. He thought these were human beings, these were politically minded human beings. They had strong ideologies, they had strong economic beliefs, and those beliefs were finding their way into decisions.
You know, what's hard to recapture from our vantage point post Franklin Roosevelt is the degree to which the framers' conservative view from 1787 that the national government would be a force of conservatism, protection of property, protection of contract, resistance against any populist movements, had borne fruit for 150 years. The framers would have seen a national government that was on the side of conservatism and regression. And indeed, when populism rose up in the state legislatures in response to the enormous dislocations of the Industrial Revolution, you saw populist legislation starting in the 1890s, worker safety laws, minimum wage laws, maximum hour laws, health inspection laws being passed and being struck down by national judges appointed by Harding, Coolidge, and Hoover. So that you had this run of invalidity. So that when Roosevelt wants to demystify the court as this sort of sacred temple, when he refers to them as a wing of the Republican Party, it's interesting. Roosevelt was not much of a law student. I learned actually for the first time from Jeff's book. He flunked 2 courses his first year at Columbia Law School. And sort of never was interested in or bought into the science of the law. So that I think what Holmes and the liberal critics would say is that, yes, it makes sense to apply the Constitution exactly as written. At least that makes sense to anybody who's never read it. But when you look at phrases like due process and commerce, you realize they leave much to be filled in. And I think probably the kind of case from, say, 1918, precursor to the New Deal, when the Child Labor Act was struck down, an act forbidding the interstate shipment of goods produced by child labor. You know, Hammer is so striking because the court had upheld lots of laws in which Congress had prohibited the shipment in interstate commerce of lottery tickets or boxing fight films or other products that they wanted to close the channels of commerce to. And yet the court held that they couldn't close the channels of commerce to goods made by child labor. The defenders of those laws said, but they stopped the spread of evil, like the earlier laws. And the defenders of the laws said the evil had already occurred. The child labor had already happened. The proponents of those laws said, no, the evil is the spread of substandard labor conditions. New York can't raise its standards as long as North Carolina is using the labor of 12-year-olds, right? And that's the evil that Congress can close the channels of commerce to. What's really striking about the court leading up to the New Deal is that they did not believe that the spread of substandard labor conditions was an evil. It was greater competitiveness on the part of North Carolina. North Carolina's willingness to employ children, like having abundant rivers and good streams and power, was a natural advantage, and the competition race ought to be won by North Carolina. And that the natural outcome of those competitive forces could not be evil. So that is what Roosevelt sees as something less than a science and more a political ideology. And as Jeff noted, we had a court that had done the Dred Scott decision, striking down any ability to prohibit slavery in the territories, a court that has struck down the major elements of Reconstruction. The first Civil Rights Acts had been gutted, and then had struck down minimum wage and maximum hour laws, child labor laws, etc. And Roosevelt is coming in, and that's what he's facing. So, what does he think about?
Well, just on this last point, not only do they not see it as an evil, but in a way they actually see it as a kind of good. Some of these conservative justices on the court in the 1930s and in the decades prior were adherents of Herbert Spencer, and one of the lines of Spencer that comes to mind in that regard is that Spencer says that in nature we see at work a stern discipline. Nature is cruel so that it may be very kind. And the idea is that, and this is the metaphor that Herbert Spencer uses to speak to these sort of broader economic phenomena, that where there's a weak herd of antelope, they're the first to be killed. And this is nature being cruel so that it may be kind, because they really had no place out there on the steppes because they were too weak to defend themselves. And so this is the kind of basic belief system which they imbibed in school in the 19th century that finds its way into judicial doctrines in the late 19th century, the sort of Gilded Age doctrines of substantive due process and liberty of contract and so forth. And it finds its way into the decisions as late as the 1930s. And by this point, it seems wildly out of step, not only with modern reality, but with the way that most people think about the role of judges.
So when do the New Dealers first perceive there's a problem?
Well, they perceived the problem on the way into office, and actually, I think that the little explosion that comes during the 1932 campaign is a reminder of what they surely already recognized at that point, which is that if they were to win, that there would be a clash with the court. And I should pause to say that Roosevelt didn't see any contradiction between the New Deal, between his plans for the nation, and the Constitution itself. There were a number of people who actually did, who on his side, there were liberals writing books with titles like Our Obsolete Constitution. Many people felt, I don't know that I would say many, but a number of people felt on the left that the Constitution itself was outmoded, that it didn't provide for a government to function in a time of acute economic distress, and that it would have to be updated, it would have to be amended, and we might need a new constitutional convention, for example. Roosevelt didn't believe this. He actually he was fond of quoting former Chief Justice White and saying that the Constitution was a broad avenue through which progress might be enjoyed. And in Roosevelt's own words, he said that the Constitution is the most marvelously elastic compilation of rules ever devised. This was a compliment. And he was, I think, instinctively, even though he wasn't a big reader of the law reviews and so forth, he was instinctively an adherent of the organic Constitution movement. He really believed that the Constitution needed to evolve and that the founders intended it to evolve with respect to contemporary realities.
You have a quote in your book, very crisp, from the end of at the end of the court packing battle. Roosevelt said, "The Constitution is worthy of reverence, not because it is old, but because it is ever new." I think that sums up the approach that he thought.
And I'll just interrupt to say that we'll pick this up again, I think, when we talk about the court packing fight. But this is present in his thinking at the very beginning, that there's nothing wrong with the Constitution as written. And there's nothing in the Constitution inherently that should prevent any of his plans from taking effect. The problem, as he sees it from the very beginning, is this group of conservatives on the Supreme Court. And this guides his thinking all the way through a long process, which I know we'll talk about, where by process of elimination he comes to packing the court as the only reasonable solution to deal with that
Right. A couple
problem.
of things worth mentioning. One is the constitutional amendment process. You know, you could easily devise a constitutional amendment, given the enormous majorities that Roosevelt had. He comes in with a Senate with 70.
Well, at the beginning of his second term, when he launches the court packing plan, there are 96 senators for 48 states. 76 of those 96 senators were Democrats.
So that
not all
right,
the remaining 20
So
were
that there would have
Republicans.
been no problem getting the 2/3 necessary to propose constitutional amendments. Simply saying Congress shall have the power to regulate agriculture, Congress shall have the power to set wages and hours, et cetera. You could devise a very simple list. But Tommy Corcoran, I recall from somewhere else, Tommy Corcoran told Roosevelt there were two problems with the plan. One was that no matter what you said in an amendment, the 5 conservatives on the court would find a way to twist it to invalidate. That's one of the problems. And number two, Tommy had in his pocket a list of 12 states where one house of the state legislature could at least decline to ratify a constitutional amendment. All it would take would be one house in 12 states not to act to prevent a constitutional amendment from getting the affirmative vote of 3/4 of the legislatures of the states. So, but early on, the very intriguing idea of Congress simply legislating that in order to invalidate an act of Congress, it took the votes of at least 7 of the 9 justices. And the argument for it is there's nothing in the Constitution that says what the vote should be, and that indeed the Constitution says that the court shall have jurisdiction over all other cases, that is appellate cases, with such exceptions and under such regulations as Congress shall make, and that Congress could regulate the process, so the court would remain independent, but it would take you would not have the act of a national Congress invalidated by a 5-4 vote. If there was really a consensus that it was a usurpation, you would have it. But that went by the wayside.
Well, there were a remarkable number of constitutional amendments that were suggested and pretty seriously considered over the course of Roosevelt's first term in office. By 1935-36, when the court began striking down the New Deal, it didn't begin doing so until January 1935, and then in short succession it starts knocking down the pillars. In May 1935, it overturns the National Recovery Administration, the NRA. In January 36, it kills the AAA, the Farm Program, and there are a number of others that go down along the way. During this period, the discussion, this is a national discussion. This isn't just a Washington discussion or happening in the Justice Department or in the White House. This is happening on the front pages of the papers, the editorial pages. It's being discussed on the radio. The country in 35, 36 becomes like a rolling constitutional convention. And groups form to advocate their pet idea for what should happen to the Constitution. Members of Congress, over the course of 1936, there are 100 different proposals in the Congress for ways to amend the Constitution to deal with the problem of the conservative Supreme Court. Some of these simply aggrandized Congress's powers at the expense of the court. A very popular idea was to give Congress a 2/3 vote veto over any Supreme Court decision, essentially making Congress the last word on the Constitution and not the court. There were other fairly radical proposals that would have stripped judicial and economic legislation, or federal legislation entirely, out of the court's jurisdiction, so that the court simply wouldn't be able to review things like the NRA or the AAA. There were others to rewrite clauses of the Constitution, to modernize them, whether the Commerce Clause or the Due Process Clause or any others. And there were others that concerned the shape and the work of the court itself, the requirement of a supermajority, as you described, whether it was 7-2 or 8-1. These were very popular ideas. The idea of imposing term limits on the justices, age limits on the justices, all of these things were proposed. A number of them had serious momentum. And Roosevelt instructs his Attorney General, Homer Cummings, and his Justice Department to very seriously examine these possibilities. And they produced these 65, 75-page memos looking at the experience of other countries, considering what the possible unintended consequences of these amendments might be, the ways in which a conservative Supreme Court, to your point, might misinterpret them. And ultimately, after 2 years of serious exploration of these ideas, Roosevelt comes to the view that he had held all along, which is that there's nothing wrong with the Constitution as written. What we have to do is something about these particular justices. He would have been happy to impose term limits. He would have been happy to impose age limits. But to your other point, he didn't feel that he could practically get these things through, that it just wouldn't happen, or it wouldn't happen quickly.
Well, age limits and term limits would clearly have required a constitutional amendment. And in fact, to add to the cynicism, what Corcoran said is there is one house in 13 states that could be bought by the railroads, and the big vested interests would simply prevent any amendment from being ratified by buying off a house. So that was the level of the distrust that was about in the land at the time. Now, what is interesting, I think, probably those civics quizzes they have in the newspaper, how many justices are there on the Supreme Court? A lot of people would get 9, even if they couldn't identify them. I even thought about your book in light of Jeff Toobin's book, The 9, you know, instead of the 9-ish. It might have been had court packing come out differently. But in fact, throughout our history, the number of justices is not set. It should consist of judges of the Supreme Court and such inferior courts as Congress may from time to time ordain and establish. And the court has as much control over the number of justices as it does over the number of judges on the D.C. Circuit or on the Fourth Circuit. Congress changes or adds to the number of judges all the time. And indeed, the number was originally 5. If you wanted something sacrosanct, that would be the original number. It's been 5, it's been 10.
It's been 8, it's been 7. It's been just about any number between 5 and 10. And the problem for Roosevelt was that it had settled at 9 in 1869 and had been there ever since. So it had not the fact of permanence, but the feeling of permanence, and no one really remembered that it had ever been anything but that. I think they didn't do any polls on this question, but I think if you had polled people in 1937, most of them would believe what most people would believe today, which is that that number 9 exists somewhere in the Constitution, right next to life tenure for Supreme Court justices.
And in fact, I believe that to enable Lincoln's war powers to be sustained, it had been increased for the reason of helping to get legislation sustained. It was increased to 10 to give Lincoln
that's absolutely right.
An appointee. So it was not unthinkable or unprecedented to change the size of the court in order to have some influence over the outcome.
And it went in both directions, because after Lincoln, when in 1866, when one of the justices announced retirement, Congress immediately eliminated that seat and then eliminated the next seat pending the next retirement, just so that Andrew Johnson would not get the chance to appoint anybody. So it went in both directions. It went up and down, usually for political reasons, and progressive presidents had come before Congress multiple times in the 19th century and said, I want another justice. Andrew Jackson wanted more justices, and they finally created another slot on the last day, his last day in office.
So Roosevelt could have come out of the box after, I mean, some of the decisions, let me just mention one of the decisions to give you a sense of what Roosevelt was facing. Railroad Retirement Board versus Alton Railroad in 1935 is particularly striking because it was the precursor to Social Security. And the invalidation of the Railroad Retirement Act seemed at the time to doom any idea that Social Security would not be struck down by this court. But Congress had started with the Railroad Retirement Act because there was no question that interstate rail transportation was subject to regulation under the Commerce Power. So that any legislation that facilitated interstate rail transportation was clearly within Congress's power. Setting up a system of pensions for railroad workers, 1/3 from the workers, 2/3 from the railroads, Congress heard ample testimony from businesses that had chosen to adopt pension plans, increased efficiency. It encouraged people to stay in their jobs, made it more easy to get rid of superannuated workers because you could move into the pension plan, and created loyalty and continuity in service, and they thought increased efficiency. And on that basis, Congress passed the law. This court reached out to strike down the Railroad Retirement Act, not just as it applied to railroad workers who plied their trade solely within one state, but even railroad workers who were on interstate lines, because they said, we don't agree that it promotes efficiency. And I often ask my students, what are there are 4 words in this opinion that the whole 40-page opinion turns off. And those 4 words from the court are, we do not agree that efficiency is improved by a pension program. A stunningly naked policy/legislative judgment.
And I would just add to that the opinion in that case, the 5-4 decision, majority opinion is written by Owen Roberts, who will make another appearance, I think, in our discussion in a little bit. Owen Roberts, like all the others on that majority, was a former railroad lawyer. And he wrote this opinion as if he were the counsel for the railroads writing a legal brief. And he not only rejects this notion in those words that you suggested, but he derides with sarcasm, there's a sneering tone in this opinion, derides the very idea that labor relations, period, of any kind, in any industry, have any effect on interstate commerce, that they have any place in the discussion. And there's a very sarcastic passage in this opinion where he says, look, if we're going to start to say that pensions have some effect on loyalty and therefore efficiency, then, then we're going to have to say that giving workers health care has some effect on these things. And then we're going to say that, providing some kind of child care for their families or education for their kids is going to have some effect on their productivity. And this is his reductio ad absurdum. And so the way this is read at the time is quite reasonably as not only an overturning of the Railroad Retirement Act, but as you suggested, a preemptive overturning of Social Security and any legislation like this in any field. And so, the repercussions, that's not one of the famous New Deal cases, but it ought to be, because in a way, the implications of that decision seem to be far greater than the implications of the Schechter decision, which killed the NRA.
So Roosevelt could have come out of the box proposing legislation, since no one doubts that Congress has authority to control the size of the Supreme Court, increasing the size to 11 or 13, even 15, simple legislation. There shall be one Chief Justice and 10 Associate Justices. As soon as it's passed, there would be vacancies. He doesn't do that. He does something else instead. And it's a fatal, fatal, fatal decision he makes not to have a simple bill added. What does he do? Tell us about how that came about and how that played out into the controversy.
Well, there's a cluster of fatal decisions that he makes all around this. And one is after a 4-year process that I described in which he's taking advice from all corners and he's engaging in all kinds of open dialogue with Felix Frankfurter and other outside advisors, that ultimately when he decides to pack the court rather than to do all these things, for the reasons we described, it's constitutional, it's quick. If the Congress passes it, it could happen tomorrow. And it's effective. You take these conservatives, you can't force them off the court with term limits or anything like that, but you can outnumber them by appointing new liberals. And so once he reaches this decision, he shuts down the process and he goes into a huddle with Homer Cummings, his Attorney General, who I mentioned. Roosevelt loved secrecy. He loved surprises. And usually this was a pretty benign thing. And it could be something as simple as surprising everybody in the White House staff with the reappearance of somebody who had been out sick for a while. He would delight in this as if it were a really big deal and everybody would sort of smile and indulge the President of the United States in this way. It could also be something very big. And usually he was careful enough to develop his plans with members of Congress. He was the most brilliant politician that had been in that White House for some time at least. But from time to time, his love of the sweeping surprise gesture got the better of him. He caused real problems for himself in 1935 when he unveiled a tax bill that he hadn't told any of the congressional leadership about. And I think that this is instructive, this example in 1935. One of the reasons that he didn't tell the leadership of Congress about this tax bill, which imposed corporate taxes and a wealth tax and inheritance tax and all these sorts of things, was that he knew they weren't going to like it and they were going to give him trouble about it. So he just announced it, and then there was a lot of trouble in the Congress about it, and he didn't get exactly what he wanted. Rather than learn from that example, he repeats the mistake in 1937 with the court plan. He doesn't share the idea of court packing with anyone. He doesn't seem to want to hear any opposition to the idea. He and Homer Cummings feel that they've not only got the perfect solution, but they've got the perfect guise for the solution. And this is, I think, the fatal mistake that you're referring to. Roosevelt, I think, found in 1935, 1936, that any time he attacked the court, that there was a fierce counter-reaction. And he was pilloried in the press, and everyone sort of rushed to form, out in the grassroots, form these Defend the Constitution clubs, and there was this great rise in support for the Supreme Court as an institution and its integrity and so forth. And so I think by 1937, Roosevelt wasn't totally confident that he could lead a charge against the court as an ideological, conservative institution. And so instead, he wraps it up in this idea of judicial efficiency and suggests that this is not just a problem on the Supreme Court, this is a problem across the federal judiciary, which, by the way, is populated by very old men, he points out. The old men, they slow down, and this is in the presidential message to Congress, by the way, that he unveils in February 37. And they're falling behind in their work.
This is before the passage of the age discrimination by some time ago.
And so he says that they're falling behind in their work, and so we need more judges across the entire federal judiciary, not exempting, of course, the Supreme Court. The problem with this, when he unveils this to the nation on February 5th, is that it's exploded within 24 hours. It's entirely untrue.
It's not just more judges. It is, for the Supreme Court at least.
Yeah.
As Jeff so
it's
well
true
details
in
in
some
his
of the
book. In the Court of Appeal, there's add to the numbers.
Right.
But at the Supreme Court, it is a new justice for each justice over the age of 70 who does not step down within 6 months. So the number would vary according to the number of justices over 70. The number
Reaching
could
a
go back all the way
15.
back down to now. What's good, as long as it didn't go beyond 15. But so it becomes this cumbersome process, which would have even numbers at at many different points in time, depending on the ages, because this was responsive to his view that this is simply about efficiency. So for every judge over the age of 70, when people are, as we all know, completely washed up, there'll be a new justice appointed as long as the number doesn't exceed 15.
And one of the problems for Roosevelt right away, and this is a problem as soon as he starts to let his aides know about this, really within a couple of days of unveiling this, he really doesn't give even his closest aides much advance warning about this, is that who's the oldest guy on this court of 9 old men in the popular phrase? There was a book that came out in '36 trashing the court called The 9 Old Men. Who's the oldest of the 9 old men? Brandeis, who is not exactly a sort of raving right-wing lunatic. And so there's this recoiling on the part of a lot of Roosevelt's liberal and progressive supporters, not only at the obvious dishonesty of the appeal that he's just made, but also the apparent slur on all old people, but particularly the one they cherished the most on this court, Brandeis. And Cardozo wasn't a young man either at this point. And so the plan, in the words of Roosevelt's speechwriter, also a judge himself, Sam Rosenman, in Sam Rosenman's words, the plan began with a black eye. And there had been a lot of talk on the right from the beginning, from 1933, about Roosevelt's intention to become a dictator and to seize total power, complete control. That's where the title Supreme Power comes from. This was a phrase that was very much in the air. And nobody else put much stock in this idea, but when Roosevelt came out with this totally disingenuous packaging of the plan, even some of his liberal and progressive supporters shuddered a little and wondered about his motives. And so he created for himself, in all these different ways, a seriously uphill battle to get this plan through.
He didn't make any reference to the trend of decisions of the court, so that the disingenuity of it was readily apparent.
And it took him a month to correct that mistake.
Is it true, Jeff, that Homer Cummins had actually had a plan something like this in mind for the lower courts without having any particular ideological twist to it, so that there was, in fact, something to be said for the origins of the plan as not being wholly ideological, though it never would have been proposed with the flamboyance with which Roosevelt produced it, obviously, had it not been for the ulterior motive. But by being disingenuous, rather than making the case that there is a legitimate role for democratic control over the court, we can come to this at the end, whether it's a good or bad idea to increase the number or to have that kind of control, he gives away the legitimacy by running and hiding from it. He concedes the most important issue in the debate. If the court is misinterpreting the Constitution by misusing its powers, why not use a power clearly given in the Constitution to Congress to set the number of justices as a corrective? By hiding that, or trying to hide that gorilla in the room, it seems to me that he gets off to the foot of conceding the illegitimacy, which should have been quite an honest and debatable proposition, whether it is or is not.
That's right. And a magazine at the time said, a magazine on the left said, Mr. Roosevelt seems ashamed of his best argument. And so there was a lot of frustration on the part of his supporters in Congress and elsewhere that they had to stick with this terrible rationale that the president had given them. And quietly, they would say behind the scenes, we all know what this is about, but publicly they had to maintain the idea that this was about efficiency. And meanwhile, this rationale had been blown up, as I said, a couple days after the launch of the plan on the front page of the Washington Post. And there's an interesting story behind that, because it was the Chief Justice of the United States, Charles Evans Hughes, who planted the story. Hughes was obviously horrified by the plan. So he accepted the entreaties of the leading political reporter of the Washington Post, Franklin Waltman, who later became an operative for the RNC. And Post at the time was a conservative paper, even more so than now. And he asked Chief Justice if he would talk to him about the court packing plan, And Hughes said, well, I can't talk on the record, but why don't you come to my chambers? And so Waltman shows up, and Hughes hands him all sorts of documents to show that the court was actually up on its work and that the efficiency argument was bunk, at least as it applied to the Supreme Court. And so this becomes a couple of front page stories in the Post over the rest of the week, tearing this thing apart. And so this is not the only time that Hughes intervenes in the court fight to tear down this rationale. But Roosevelt created a real problem for himself, as we've been discussing, and it takes about a month of very, very bad press, of constantly losing ground, and of his aides coming to him almost every day saying, please come out and be direct about why we're doing this. It takes a full month before he goes out and gives a couple of speeches, one a big speech to a Democratic dinner and the other a fireside chat, where he finally makes clear what this is all about. By that point, he's put himself in a fairly deep hole.
And then the court plays a role in its own recovery. The court at that time is made up of 4 conservatives: Butler, Sutherland, Van Deventer, and McReynolds, 3 progressives, and 2 justices that are in the middle-ish, the Chief Justice and Justice Owen Roberts. So what's the court's role, and what's the great historical debate over that role?
Well, just to pause for a minute on the court itself, these 2 swing justices, Hughes and Roberts, aren't really swing justices in the truest sense, in that they don't seem to have a kind of a centrist line that they take. You had the 3 strong liberals, Brandeis, Cardozo, and Stone, and then you had the 4 conservatives known as the 4 horsemen. But by 1935, Roberts, as we described with respect to the railroad case, really seemed to have thrown his lot in very happily and wholeheartedly with the conservatives. And it was not only that decision, but he had also written the decision that killed the AAA, the farm program, in which he argued that the federal government had no business regulating agriculture, because agriculture was a local matter reserved under the 10th Amendment to the states. And as for drought and deforestation and huge rotting surpluses across the country, in the words of that opinion, Roberts said, this was not a national crisis, this was a widespread similarity of local conditions. So there's not much hope for Roberts by 1937. It's really a court without a center, and Hughes' centrism seems to be flitting from left to right, trying to create some room for others to join him and never succeeding. He had really lost control of the court. But in the middle of the court fight, what you're suggesting, we have what's commonly known as the switch in time that saved 9. And that really refers to a pair of decisions. The first one announced at the end of March in 1937. And that upholds a Washington state minimum wage law that is virtually identical in every respect to the minimum wage law that the court had killed less than a year ago. And it's Roberts who was in the majority in both cases, so he has switched. And a couple of weeks after that, not even a couple of weeks after that, more significantly, the court upholds the Wagner National Labor Relations Act. And this is a hugely significant set of decisions. There were 4 cases decided that day. And Roberts, again, is with the majority, and Hughes issues a ringing opinion in that case that observers said sounded like he was delivering the final judgment. It was a great triumph for Hughes, who had been arguing for an expansive reading of the Commerce Power since he was on the court the first time. He was on the court in 2 different stints back in 1910 and 1916. So with these 2 decisions, the court has really pulled the legs out from under the court plan, from under the court packing plan. But Roosevelt continues to fight for a range of reasons. One, because he thinks that this is not a permanent switch, and that if Roberts has switched, Roberts is just going to switch right back as soon as the court plan is dead. He's actually not entirely wrong about that. And he also sees that this fight that he's been having with the Supreme Court is now a fight between himself and the Congress. And he sees that if the conservative Democrats, who have just aligned themselves on this with the Republicans, if they can defy him on the first thing that he's asked the Congress to do in his second term, that they're going to defy him on all manner of things over the coming years. And he's right about that as well.
And some have suggested that because the court's secret conference vote occurred before court packing was announced, that the court wasn't responding to the threat of court packing. But you have a good response to that, I think.
Well, Roosevelt argued to the end of his days that, in his words, I lost the battle, but I won the war. I didn't pack the court, but I got the court to switch. And he said you'd have to be pretty naive to not see a connection between the court packing plan and suddenly the court upholding the New Deal. But he didn't actually know at the time, and no one knew at the time, that, as you just suggested, that the court had actually voted in conference to uphold the minimum wage in December 36. And the court packing plan wasn't announced until February 37. And now they didn't decide the Wagner case, the Wagner cases, the National Labor Relations cases, until later. But the switch really had been made by Roberts before the court packing plan was announced. And some have argued to this day, there are some revisionist legal scholars who suggest that this shows that the justices weren't at all concerned actually with political events, that it was just the internal evolution of Roberts' thinking. And I think that my view, and I'm not the only one, I think, who's made this argument, my view is that Roberts, when you really come to understand Roberts as a human being, which is something that I really try to do in this book, and I'm not psychoanalyzing him, I'm not trying to delve into psychohistory here, but I think based on his statements and his positions and the things that other people who are close to him said about him, I think you can get a sense of Roberts as a man who cared very deeply about not only the public's esteem for the court, but the public's esteem for him. And he had really suffered in 1936 when the court knocked down the AAA, when the court knocked down that state minimum wage. Most of the ire was directed at him in the same way that a lot of it is directed today at Justice Kennedy. You don't imagine for a moment that Justice Scalia or Justice Thomas is going to be with you, but you think maybe we could hold Kennedy on this one. And then Kennedy goes with them, and everybody's on the left is angry at Kennedy. And it was the same sort of feeling. Because Roberts had moved around a little bit, liberals were enraged at Roberts, and he had really taken a public beating over these decisions. And then there was the landslide victory of Roosevelt's in 1936.
It was stunning to many members of the court. Were stunned at the magnitude of Roosevelt's victory, which immediately precedes this. And whether court packing had been announced or not, Robert surely had a sense that in one way or another, Roosevelt, with this extraordinary, greatest electoral mandate ever in American history, that Roosevelt would be coming after them. They might not have known what form it would take, but that were they to continue on this collision court, he's coming. And that's known even before the particular court packing plan. And in fact, I'm not at all surprised if the justices, the public may have thought the Supreme Court is fixed at 9 forever. But it would not, to me, knowing how adept the justices are at figuring this out, that they might not have seen this as a possibility. However surprising it was to his political lieutenants. Certainly there had been discussions of something like a 7-2 or 8-1 supermajority requirement enacted by Congress before the 36 election, so that it's in the air, and this mandate is there, and the collision course is there.
And as I mentioned before, there is a lot of momentum by this time behind the idea of various constitutional amendments. Even though Roosevelt by this time had privately ruled it out, there was a lot of momentum, and there were groups that were continuing to form, and very distinguished people joining these groups, and members of the Senate stepping forward to lead these groups. And in the first 10 days of the congressional session that began in 1937, 50 proposals were introduced. And so it was very much in the air that, and it was remarked upon everywhere in newspaper editorials and in the coverage, that now that Roosevelt has won this shocking, sweeping victory, which really surprised everyone by its magnitude, that he now had a mandate to do essentially whatever he thought he needed to do to face down the Supreme Court.
So after the quote-unquote switch, what comes through clearly to me from Jeff's book, is that Roosevelt could have gotten any one of several compromises through the House and the Senate. Certainly a straight-up bill to increase the size of the court to 11. No question about it. Roosevelt feared that with 4 conservatives still on the court, plus Hughes and Roberts being unreliable, that made 6, so that a 6-5 vote could still invalidate the New Deal. He wasn't comfortable enough with that, right?
That's absolutely right, and there's one other reason too, which is one of the great ironies of this entire episode, and that is that the Senate Majority Leader was a guy named Joe Robinson from Arkansas. He was one of these old, sort of classical Southern Democratic bulls of the Senate, and he was not in his heart a New Dealer. Most of the Southern leadership of the Congress, particularly the Senate, were not in their hearts New Dealers, but they had backed it down the line out of public loyalty to Roosevelt and because they didn't really see that they had any choice, particularly during the Depression. But they had really been chafing all along. And as an acknowledgement of the many acts of great loyalty that Robinson had delivered to Roosevelt, back in about 34, 35, Roosevelt makes him a sort of quid pro quo promise that he will have the next seat on the Supreme Court. This had been Robert's great dream ever since he was a boy in Arkansas, to sit on the Supreme Court, not to sit in the Senate, but to sit on the Supreme Court. And so this is well known in Washington, and it's the biggest open secret in Washington. And so Roosevelt sees that if he gets 2 justices, one of them is going to be Robinson, who's not going to vote for the New Deal anymore once he's on the Supreme Court.
Right.
Then he gets to appoint a liberal, and they cancel each other out, never mind what Roberts and Hughes are doing.
Right.
So
he's stuck with this.
He's absolutely
And even
stuck.
when, the other thing that pulls the leg out from under Roosevelt pulling off this victory, even after the switch, is the retirement of Willis Van Deventer. Quite clearly calculated. There's no doubt. I suppose that Van Deventers did this to pull the plug on court packing, that would give Roosevelt at least a fourth progressive. But here again, Roosevelt is caught in the fact of the promise to Joe Robinson, who was well regarded by his Senate colleagues, all of whom, when Van Deventer's letter came, piled around him on the floor of the Senate to congratulate him and to call him justice. The Nation magazine was livid over the idea that after all this struggle, that someone whose liberal credentials were utterly unreliable, but who had just been a loyal lieutenant, it would now be a Southern white guy from Arkansas would be taking that place. So there was this Roosevelt temporized because he didn't want to move one way or the other. He sort of told Joe Robinson, if you can get 2 more seats through, now we'll have 3 and you can have 1.
And so Robinson is in this terrible position of fighting to pack the court, a bill that he doesn't believe in, to support a program, the New Deal, that he doesn't believe in, to get himself the dream of a lifetime, to get himself a seat on the Supreme Court. And there's nothing else he can do. And so he throws himself into this. And bodily he throws himself into this. And remarkably, and this is I think one of the most remarkable things about this whole story. It's very easy to say, as I think a lot of biographers have done, that the writing was on the wall from that first day when Roosevelt unveiled the plan. As I said, it began with a black eye. And the standard telling of this story is everybody knew that this plan was dead from day one, and why didn't Roosevelt recognize that he was living in a dream world? Well, remarkably, public opinion was pretty much split evenly from the beginning and stayed pretty evenly split throughout. And there was this chance, as Walter described, all the way right until the bitter end, that Roosevelt could get 2 additional justices and have a court of 11, or get 4 additional justices and we'd have a court of 13 today. And so there's still a chance that Robinson can salvage 4 justices, one of whom would be him, for Roosevelt. So he throws himself into it, and he goes around sort of collecting all the chits that had been out there for years, and bullying people and cajoling people in a way that you wouldn't see until Lyndon Johnson took this job not long afterwards. And it looks like he's going to do it. And that the only possibility out there for the opponents of the bill was to filibuster. And filibustering in those days didn't involve just saying that you were going to filibuster. You actually had to stand there on the Senate floor.
Right.
and you know, get a glass of milk and, you know, read your mother's recipe book out loud until you collapse. And filibusters often backfired for this reason, because of the public spectacle. So it wasn't clear that they were really going to have the guts to do it. And so Robinson, at the beginning of July 1937, in a heat wave that Washington hadn't seen in decades, opens the Senate debate on the bill and stands in the well of the Senate, shaking his fist, pounding his fist on the mahogany desk, calling out people in this, you know, in the galleries above, and almost coming to blows with his opponents on the Senate floor. And in the middle of this, Robinson turns purple and collapses on the Senate floor. And he's carried outside, and they sort of fan him, and they tell him that he should go home and drink some milk and take a day off. And so he does. So he goes home, and he's not heard from for the next day. And in the morning, his housekeeper comes in and finds him dead on the floor of his apartment across the street from the Supreme Court. And it really is the death of Robinson, I think, that is the reason we don't have a Supreme Court of 13 today.
Right, that's exactly right. There's no question about it. And also, that removes Roosevelt's problem. At least his problem with filling the Van Deventer seat, because the promise obviously does not follow Robinson to the grave. And Roosevelt delighted, he was fiercely angry at the Senate Democrats and the Republicans who had opposed him on this. And he loved surprises. And he sends his nomination to the Senate in a handwritten note that is opened on the floor of the Senate. There were not hardly any Southern true supporters of the New Deal, but there was one, Hugo Black of Alabama, who was probably the closest thing to an actual socialist/communist we had in the Senate. He favored he fought for the 30-hour work week, for the national minimum wage.
Which Roosevelt thought was too radical.
Yeah, Hugo Black was too radical a leftist for Hugo Black, who was a Southern populist. Hugo Black had terrorized the big corporations by investigating their misdeeds. He was a muckraking investigator of corporate malfaction. Saw himself as a widows, orphans, and working persons tort lawyer in Alabama. Ran against the machine, but considered so fiercely left that when his appointment was announced, it stunned the Senate. And Roosevelt was delighted because he thought because he was a senator, they would have no choice but to confirm him. Indeed, 3/4 of the Republicans voted no on his nomination. But the nomination of Hugo Black, and also was an insult to the court in many ways, because Hugo Black had 1 year of college and no law school, so that for all the majesty and the learning of the justices, he was sending what was then seen as this rube, radical leftist Southern populist rube.
And he had also been out there in the midst of the court fight, not only backing the president, but saying at one point, look, if what it takes is we need to have a court of 75, I'm for a court of 75.
Right. Yeah, so he was a foe of corporate America and a leftist. So that actually changed. Now, you know, interesting, we had Owen Roberts switch only because John J. Parker of North Carolina had been defeated for confirmation to the seat that Owen Roberts got, or there might never have been a switch. So there we are, and then quickly that gives actually, with Roberts, more or less that gives Roosevelt control, but the vacancies come fast after that. So you have William O. Douglas, Felix Frankfurter, Robert Jackson coming in rapid succession. By 1941, 7 of the justices had been appointed by Felix Frankfurter. So in almost no time, we had this remarkable turnaround in the court, and that is the spectacular ending of Jeff's book. I clerked for Hugo Black in 68, 69, and he still believes that court packing was right, and as late as 68, 69, he believed that court packing was a great idea. and should have been done. Let me just read a quote to Jeff on this final notion of whether court packing was a good idea or not. The Senate Judiciary Committee issued a scathing report, 10-8, condemning the court packing bill and reflecting the views of the mainstream established corporate bar like the ABA. And they ended the summary of the charges against the bill by saying it is a measure which should be so emphatically rejected that its parallel will never again be presented to the free representatives of the free people of America. Is that the case?
I think that's the case. It's hard to imagine. I mean, with all the trouble that President Obama is seen to have with the current Supreme Court and all the trouble that seems to be coming, you don't hear anybody suggesting, as you did beginning in 1933, that the court ought to be packed or that serious action ought to be taken to curb the court. It's really entirely focused on the appointments and the waiting game.
It clearly would have weakened strong judicial review to have had the court's opposition to the New Deal and to social legislation at the state and local level as well, which the court was also invalidating, overridden by a new court where Congress had added new members. Whether that's a good or bad thing really asks the question of whether you think, on balance, strong judicial review has been a good or bad thing. We have Dred Scott, we have the invalidation of the Reconstruction Amendments, we have the validation of the most repressive regimes of suppressing free speech during World War I. It's really not until 1938 that the court ever does anything remotely progressive. So I'll end with this. When I ask whether, on balance, judicial review has been a good thing, I'm reminded of what one of my other favorite works of history begins with. Simon Chambra's History of the French Revolution opens with a vignette about when a French journalist asked Zhou Enlai, the Chinese premier, asked Zhou Enlai, what, in your view, was the significance of the French Revolution? And Zhou Enlai's response was, it's too early to tell. We'll end with that, okay?
So let's take just a few minutes to take questions and comments. And even while we're doing this, feel free to have a drink. And afterwards, we can take don't feel like you have to rush out the doors. We can mingle and have a drink as well. So let's take a few minutes. And let's start off with Chris back here. And when you do ask a question or make a comment, just identify yourself for the benefit of the webcast and for all of us to know.
Hey, Chris.
Chris Hayes from the Nation magazine. This incident split our editorial board quite brutally, actually, and occasioned one of many internecine factual struggles. I want to ask a methodological question. I'm reading the book now, which is remarkable, and public opinion plays a very important role. And I'm very curious about how, as a historian going back to that period, you divine public opinion. How you gauge it. There's not really the dawn of real kind of rigorous scientific polling. So when you say the public was split, or how did you go about trying to ascertain where the public was on a policy issue?
Well, it's a really good question, and it was a question that plagued Franklin Roosevelt because the so-called science of polling was really very new. Gallup really only got started in a significant way in 1935. And so I had these polls to use. If you get the big bound volumes of Gallup, this stuff is all clustered in the first few pages because this is the very beginning. And so I don't know how well you can trust this stuff. And so I tried to be very careful, very circumspect in how I actually use it. I tried not to make any grand claims beyond what I just set up here, which I think is pretty sound about where the public was on all this. But, you know, what's interesting I didn't really do anything because I didn't think there was much that I could do to divine public opinion beyond that. But one of the interesting things to me, as I suggested, was to sort of watch Roosevelt struggling to do that very thing. That despite the sort of the shrill outcry in the nation's newspapers, and despite the fact that the editorial pages were wildly, almost universally against him on this, and despite the fact that a surprising number of members of Congress in his own party were opposing him, Roosevelt had this incredible faith that he could read public opinion, because he had so successfully. He had advisors coming to him late in 1936 telling him that he was in trouble. And he really believed that the people were with him and that he was going to not only win, but he was going to win big. So he had a tremendous sense of confidence, not only that he could bring the public along, but that he could read the public mood. And it was interesting to me to go dig a little bit deeper in the archives and to find the kind of information that was coming to Roosevelt from around the country, from local committeemen in the Democratic Party and from local newspapers that were sympathetic and so forth, saying to Roosevelt, don't believe what you read in the newspapers. Don't believe what the members of Congress say about the letters that are coming to them and so forth, opposing the plan. The people here in Georgia or the people here in Texas or fill in the blank are 5-to-1 in favor of your plan. And they were putting numbers on it. And I don't know how much stock Roosevelt put in any specific set of numbers, but he really believed that the intelligence he was getting from the field was better than what he was reading in the papers or in the Gallup poll. And what he was reading in the Gallup poll, as I suggested earlier, wasn't that bad. That he hadn't actually even tried to sell the public on court packing, and he started with a level playing field, as he saw it.
Right here in the middle. Sorry, Ken.
Yeah, my name is Ed Newton. I'm a freelance journalist. And you suggested that nobody in the Obama administration has considered packing the court at this point, the John Roberts court. And after listening to your discussion, my question is, why not? You know, why? Is this a political calculation, or is it or is there some sort of constitutional question that you haven't addressed here?
Well, it's entirely constitutional, but it's hard to imagine this one getting through. It's hard to imagine anything getting through the Senate, but it's hard for me to imagine this in particular getting through, or President Obama arguing the case with a straight face. And I think that one of the things that Roosevelt ran up against, we didn't really touch on this in our discussion, but there's the precedent question. Really, any president could propose this, any Congress could do this. But one of the things that really struck fear into the hearts of liberals and progressives in the middle of this court fight was the idea that, well, okay, we trust Roosevelt, and if he packs the court, we know it's going to be with New Dealers, and we're gonna like them pretty well. But what's the next president going to do, or the president after that? And doesn't this just become an endless game with presidents changing the size of the Supreme Court once the precedent has been established? And so it's very hard for me to imagine anybody making the case for this kind of reform today. I don't know what you think. But.
Yeah, you know, one reason I think it might have arguably been legitimate is that it takes such an extraordinary supermajority to pull it off. And in the 32, 34, 36 elections, the country had, at some level of real thoughtfulness, accepted the two basic constitutional propositions of the New Deal. That the national government had the authority to regulate the national economy, and that government and state and local governments could ameliorate the harshness of the industrial workplace with worker safety, consumer, and child protection and worker protection laws. The country had just overwhelmingly accepted those two fundamental propositions. And for the court to reject both of those propositions in the face of the overwhelming numbers that a correctly played hand by Roosevelt would have gotten this through. And it might have been the only time we know in this century when you could have had the kind of supermajorities and the kind of national consensus on the one hand with the court on the other where that would have been possible. And then secondly, starting in 1938, October term 1938, come back to it if we have a chance, until 1970, we have a progressive court for the first and only time in our history. So that now I think the notion of weakening the constraints of judicial review would not be so one-sided. There wouldn't be, I don't think you could get half the nation on board.
I would just add to that, and again, we didn't really touch on this, but Chris, your publication, The Nation, and others on the left, argued that the real problem was not even this set of conservatives on the court, it was judicial power per se. Mm-hmm. And they argued that judicial review had been usurped from the beginning, that it was not intended by the founders, and that really judicial power was fundamentally anti-democratic and ought to be curbed. And you'd be hard-pressed to find too many people making that case today, and maybe it's the experience of the Warren Court and the burst of progressivism that we've seen in relatively recent history on the court. But I think the argument today on the left is not that we ought to be curtailing judicial power, but that we just want control back. And we want the right kind of justices, again, to be in the majority. The nation, and this was part of the problem of the split that Chris referred to, the nation generally felt that court packing was fine, but it didn't get at the real problem.
There's a question back there, yes.
Chris, were you the bureau chief back then? Dio?
Thank you so much. I found that very informative. So my basic understanding of the sort of founding of the nation and the intentions of our framers of the Constitution was that the government ought to be run by elites, people who were lowercase Republican, who were disinterested. Based on some of the conversation that you've had today about the sort of the politicization of the court, the idea that Roberts would be even attuned to public opinion, is interesting insofar as I feel like there has been a shift from the disinterestedness of the framers, the people who were in the executive and legislative branch at an earlier time, and the Supreme Court at this point. And so I wonder whether you feel that the leisured class, the most educated, the elites, who now populate the court, and we could talk about the two very good schools from which most of the current Supreme Court has been educated. Do you think that that's something that is justified? Do you think that's something that is good for the country? Do you think that there is a possibility for disinterestedness to come from different sources in the contemporary moment?
Well, judicial review is necessarily a variant institution in a political culture whose predominant commitment is to majoritarianism. And it was less of an anomaly at the beginning when the other institutions were intended to be elite as well. The House was seen as an elitist institution because 65 national legislators replacing 3,000 state legislators when power shifting with the adoption of the new Constitution. With these large congressional districts instead of electing a friend and a neighbor. A Senate that is selected by state legislators and not even by the people. So what happens is we see the inevitable rise of democratization through the expansion of the franchise, first to poor whites by the reduction of property qualifications, for voting. Then, the dead letter of the 15th Amendment, rendered a dead letter, by the way, by the Supreme Court. It didn't just happen. The Supreme Court nullified enforcement of the 15th Amendments. But the 17th Amendment on direct election of the Senate, the 19th Amendment enfranchising women, the expansion, this democratized the rest of it. So it does leave the Supreme Court as something of a variant institution. That's why I always do like the president's instinct. Empathy may not be the politically correct word to use or the politically popular word. But I think what the president really has had in mind is what Holmes said, the life of the law has not been logic, it has been experience. And a range of experiences is useful. The last The last justice we had who played a prominent role in the political life of the nation, who was on the ground a lot all over the country, was Thurgood Marshall.
Judge and freelance correspondent, thank you for your two comments. Who created the term New Deal? And at that time, where people realize what's the true color of the new term, New Deal, particularly for the people criticize and opposed FDR, did they use the socialism? And both FDR and Obama, they come to the power with popular vote and practice socialism. From you knowing the FDR, can you predict what's going to happen to the Obama? And what's the lesson Obama can learn from FDR administration? Thank you.
And did you see FDR's birth certificate?
The term New Deal was something that his advisors helped coin in the course of the 1932 campaign. I think it's, I may be wrong about this, but I think it's Ray Moley who tends to be credited with creation of the term, but maybe it was Sam Rosenman, actually. But as to whether they knew what it meant at the time, I think they understood at a basic level that it meant what Walter just described, this basic understanding that you said existed in at least an inchoate way in the country, that people had accepted this basic premise of government intervention, that these were national economic problems. These were not 48 states with similar problems, but these were national problems that needed to be tackled nationally. Roosevelt had been talking for decades, literally, about his idea of interdependence, and that this required concerted national action. And so that was the fundamental premise of the New Deal, and it required a shift in the relationship of states to the federal government. It required a shift in the relationship of individuals to the state and to the nation. But this was something that was, I think, broadly accepted or increasingly accepted by the country. In terms of what shape that would take in programs, not even Roosevelt necessarily knew that when he was elected. There were certain reforms that had existed that liberals have been working on for some time. Social Security wasn't a brand new idea when Roosevelt proposed it or signed the bill. Some of these ideas had been in play literally for decades while liberals and progressives had been out of power during those long years of Republican rule. Others were really improvised in those first 100 days and thereafter. But they all served this fundamental mission. And you're absolutely right. Roosevelt was attacked by his critics for being a socialist, for being a communist, for being a Bolshevist, for being a collectivist. The list was very long, even more creative than the one we have today. He didn't put much stock in this, but there was certainly tremendous fear, I think. There was both real deep-seated fear on the right and a lot of manufactured fear on the right. And so in this way, I think it's very parallel to this moment, that nothing less than the survival of democracy was at stake. If Roosevelt succeeded in making all of this happen, he would extinguish the states as entities, he would extinguish individual liberty, and we would be living in a centralized dictatorship.
One last question, please.
Thanks. Phil Fleming, following on those interesting answers. If you accept the premise that the confirmation process is essentially broken since the Bork fight, and it's interesting to note that in some other liberal democracies that do not have lifetime tenure, they have limits of 10 years, 15 years, so there's turnover, and they don't have the confirmation battles that we have. And whether it's term limits or some other way, do you see a way to get there, Walter?
I do. Actually, my colleague Paul Carrington at Duke and others have an ingenious proposal, I believe, to be truly constitutional, which is that the life tenure of judges of the Supreme Court and the other federal courts is the life tenure of an Article III judge. And they believe that there's no reason why at a certain age judges of the Supreme Court could not be assigned to senior justice status of being assigned to sit on the courts of appeals. Justice O'Connor, just read an opinion by Justice O'Connor as a Court of Appeals judge recently. She has to go around and sit. That the Article III life tenure means you never fear of being thrown out of work without a salary. You know, the compensation can never be reduced, and you have life tenure. That's to protect your independence. You can serve forever as an Article III judge, but your time on the Supreme Court would come to an end at a certain age or after a certain term of years. Either way, it has the same effect. If it was a 15-year term, there'd be no incentive to put a 35-year-old on the court. And I don't think anybody should be on the court who hasn't had his or her first midlife crisis. That it would be better to have older folks and not have this incentive to have, you know, these overly youthful justices. I think it would work, and their proposal is to make it effective for the presidential election after the next presidential election, so that behind the veil of ignorance, we don't know, you know, who would be president. Wouldn't affect any presently sitting justice. It would not take effect for a very long time. But I think the cult of personality that goes with the lifetime appointment would be reduced. The justices take themselves too seriously. I actually was one of those. We can sort of maybe end with this dust-up we saw at the State of the Union, whereas, as I recall it, the president said, "You're nothing but 5 political thugs in robes," and then Justice Alito jumped up and shouted, "You lie!" Right? It was something like that. But I actually thought that there's nothing wrong with the president criticizing a decision, and nothing wrong with Justice Alito saying that's not true if he doesn't agree with it. It's just a good rough and tumble. These are lawyers that got confirmed, and I think we ought to think of them more that way than as high priest of civic religion. Thank you all.
Jeff, Walter, this has been great. Thank you.
Thank you, sir.
And thank you all for coming.